Anybody who doesn't know me, my name's Ellen Janko Bacon. Welcome to today's seminar, Confidentiality in Collaborative Teams. Please feel free to use the chat box to ask questions. We will monitor the chat box and your questions will be answered as time allows. At the end of this session, please follow the directions that will be sent in the evaluation email for the online attendance certificate process. Please fill out the evaluation, whether you are applying for CE credits or not. A certificate of attendance for financial neutrals and mental health professionals will be included in the evaluation confirmation. If you've called in, please send an email to the office with the phone number you're using so your attendance can be verified. For our attending attorneys, the first code of today's program for the CLA credit is collaborative. The first code word is collaborative. We have two esteemed presenters today. Ken Novenstern, a partner, not only a partner, but my partner at Fredman, Bacon, and Novenstern in Westchester, White Plains, and Mount Kisco, has been practicing matrimonial law for over 37 years. The firm's philosophy
40.
affect what? How many?
40.
40. You got to update this. The firm's philosophy is that effective representation must reflect the unique nature of each client's circumstances. To that end, Ken has expanded his areas of expertise beyond litigation to mediation and collaborative law since 2004. Having seen the impact of actively litigated matters on people's lives and finances, he has gained a greater appreciation for the importance of alternative dispute resolution methods in the matrimonial field. Alana Katz is a practicing family therapist, mediator, and family specialist, and one of the first therapists in New York to join the NYACP. She was also one of the first therapists in New York to become certified in emotionally focused therapy, an approach that helps clients understand and change their patterns in key relationships. Now a certified EFT trainer, Alana also applies her knowledge of relationships to help clients intercept difficult patterns in the divorce process. She presents nationally and internationally, and her private practice is in Manhattan. Welcome to you both, and welcome to all of you.
Wow. All right, good. We got to leave all that formality to the side because I feel like we're just looking at a room of friends. So we hope there'll be time to talk with you. This is an hour that we have together, but I want to say the fact that we're even having this conversation together, in truth, came about by accident. I mentioned to a couple of people in our organization that I was in one of my collaborative cases, and one of the attorneys who I continue to hold in very high esteem mentioned something about their attorney-client privilege. I was really surprised, because my agreement with clients says that there is a waiver of confidentiality within the team, right? And I generally ask that my clients sign a confidentiality waiver so that all the professionals on the team can speak freely to facilitate a resolution on their behalf. And in fact, if I speak to a client's therapist, which I sometimes do in terms of getting to know them better and seeing how I can support them through this process, I tell that therapist before they say a word about that waiver of confidentiality within the team. And then I say, given who I am and what I do, what part of your work would you like me to know about, so that I don't wind up hearing anything that I wouldn't share? So, spoiler alert, you might leave here with more questions than answers, okay? Maybe what we will do is heighten some of our awarenesses of differences based on our professions that maybe we haven't put a spotlight on quite until now. And how do we want to go forward? How do we want to represent this amazing work that we do, I think, in collaborative? What do we say we do? How does that match with what we do? And what's our elevator speech really going to be? So, and maybe as a move towards shaping greater clarity, maybe it's okay that after 20 years of being an interdisciplinary group, maybe it is time to take a fresh look at this, bring fresh eyes to this question, and see how we want this to be. So buckle your seatbelts. We're going to be moving quickly. We have 54 more minutes. I'm going to turn it over to Ken now, who's going to speak from a legal perspective on this question.
So thank you, Alana. When Alana and I were preparing for this, and we were discussing the differences between how a mental health professional or financial neutral might come to this versus an attorney, I gave her an example of a case, one of my early collaborative cases in the mid 2000s, where my client advised me that his girlfriend was pregnant. And, my feeling was that that was clearly covered by confidentiality. He did not want his soon to be former wife to know that. And it certainly could have impacted the entire case in many ways. And so I made the decision that I could not disclose that information, that it was confidential. And so when each of us as attorneys signs our registration or renewal every 2 years with New York State, and we pay our $300 or $400, I think we have to check a box in there to the effect that we've looked at the ethical rules for New York State. And so, in preparing for this today, I mistakenly printed out 275 pages. Sorry, Ellen, of the New York State Bar Association New York Rules of Professional Conduct 2025. And while I had only intended to print out a short summary, I'm glad that I printed out the entire set of documents. I'm sure many of you, Mary, Myra, remember that when we started practicing, there were disciplinary rules and ethical considerations. The rules of conduct were revised, I think, approximately 10 years ago, and they are very similar. We don't call them disciplinary rules. Now, the confidentiality of information rule is Rule 1.6, and there are no specific ethical considerations, but there are comments. And so I just wanted to go through Rule 1.6 and then discuss some of the comments as they relate to our work. And then I think part of what Alana and I would like is for people to participate and discuss situations that have arisen in their cases in relation to this. Also, in going through part of these 275 pages, it's interesting because here in 1.6, there is reference to the client giving informed consent, which arguably happens in our cases, but not necessarily a blanket informed consent from day one of the case through the end of the case. And this concept of informed consent really permeates the rules. At 1.8, talking about specific conflict of interest rules. There's discussion of informed consent, and one of the rules there talks about the idea of the lawyer shall not accept compensation for representing a client from one other than the client. So, for us who have been paid by the parent of a client or the brother of a client or whatever, we really need to be mindful that we need to make sure we get that informed consent, and best to do it in writing all the time. Oh no, you've got to go downstairs. Go to Sherry. Um, just came back from his dog walk. So going back to the confidentiality rule 1.6. 1.6a, a lawyer shall not knowingly reveal confidential information as defined in this rule, or use such information to the disadvantage of a client or for the advantage of the lawyer or a third person, unless one, the client gives informed consent as defined in Rule 1.0J, two, the disclosure is impliedly authorized to advance the best interests of the client and is either reasonable under the circumstances or customary in the professional community, which is interesting from our perspective because clearly we're having that kind of conversation with the client. Then three, the disclosure is permitted by paragraph B. Then there's the definition of confidential information, which in the first sentence talks about information gained during or relating to representation of a client, whatever its source, that is A, protected by the attorney-client privilege, B, likely to be embarrassing or detrimental to the client if disclosed, or C, information that the client has requested be kept confidential. Then it goes on to say what is not ordinarily included as confidential information. And in subparagraph B, the rule discusses that a lawyer may reveal or use confidential information to the extent that the lawyer reasonably believes necessary. And then it goes into situations which I think we all learned about in law school first year, to prevent reasonably certain death or substantial bodily harm, prevent the client from committing a crime, or to withdraw a written or oral opinion or representation previously given by the lawyer. And I'll just skip down to secure legal advice about compliance with these rules. In other words, when one of us needs to confer with ethics counsel concerning a situation, to defend the lawyer, the lawyer's employees and associates against an accusation of wrongful conduct. My understanding of that is that where a client makes some kind of claim or attack against us, that means that confidentiality goes out the window and we have the ability to communicate confidential information so that we're on an equal playing field with the client and the client can't just attack us. We have the ability to defend ourselves, to establish or collect a fee, and when permitted or required under these rules to comply with other law or court order. And going to the comments, I won't read as much as I would like, but the comments talk about the fundamental principle in the client-lawyer relationship is that in the absence of the client's informed consent or except as permitted or required by these rules, the lawyer must not knowingly reveal information gained during and related to the representation, whatever its source. The lawyer's duty of confidentiality contributes to the trust that is the hallmark of the client-lawyer relationship. The client is thereby encouraged to seek legal assistance and to communicate fully and frankly with the lawyer, even as to embarrassing or legally damaging subject matter. The lawyer needs this information to represent the client effectively, and if necessary, to advise the client to refrain from wrongful conduct.
Can
And
I just ask you here, Ken? So I think my question is, when you became a collaborative lawyer and decided to work in this model, did it feel to you like you were making foundational shifts in that agreement that your client signed off on, right? In other words, not secretly or I know what's best, but that you discuss with your client and they knowingly agree it's going to be different than that. I mean, I'm a card-carrying family therapist before I became a mediator or collaborative professional. And so for me, that leap to the client is the family. The client are the children who I might not even meet, but the client is that collectivity that is changing its form. But I'm wondering how you hold the complexity of that straight and narrow definition of being a lawyer with being a collaborative lawyer.
It's a great question. Certainly, I made a shift when I started doing the trainings in 2004. And it wasn't just overnight because, you have to have that opportunity to develop experience in the area. And the reality is that these confidentiality issues come up. I don't know if rarely is the right word, but it's not something that happens every day. When it happens, I think it's something that jumps out to you as the attorney as something that you cannot maintain that level of transparency that we talk about in collaborative, that you have to make a judgment call. And I've had situations where I've said to the client, look at, this, we're supposed to be transparent, and it could limit my ability to represent you in the collaborative process. Because there are other situations where clients will tell us something financial and think that, we're not required to disclose that. And in that kind of situation, I might have to make the decision that I can no longer represent the client if they maintain that I cannot disclose that information. So,
That feels like a bright light event.
right,
They can't keep assets a secret,
right.
right? That doesn't confuse folks. Okay. So can you think of an example? I know you mentioned the one about the pregnant girlfriend, and there was some chat about that in from the group, sort of saying what happens when 2 months after signing, the former spouse learns that there's a baby, you
Mhm.
know, how will it affect their relationship to the process, the integrity of the process, perhaps?
Right, right.
Um,
Yeah, yeah, no, I mean, in terms of different situations, I have a case now, which is not a collaborative case, but a case where I've been involved with the client now for 2 years, and it's a non-marital child situation, so custody access. And my client has seen what happens when he takes tests, substance tests, and he sees how that information gets transmitted. And, it almost becomes that game of telephone where everyone in the process all of a sudden knows his test results. And right now, there's nothing compelling him legally to take tests. But he's expressed to me that he's very concerned the way that information gets out there and it becomes so readily available to everyone in the process. So, you know, it's it's a balancing, and it's taking into consideration the client's concerns. It's taking into consideration the type of issue that we're talking about. And so, in regard to the collaborative process, I certainly be curious if other people have had situations come up like this, where they felt that they owed the duty to the client ahead of the collaborative process. But I do think it's challenging. Randy, we,
No, 1 year and 10 years from now, I'll stop doing that. Hi, everyone. So I think it's tricky, and I think it's maybe a little bit different with attorneys and mental health professionals, but maybe not. To my mind, what I find most kind of difficult, and there's another topic, but it ties in, is that some clients really don't have a clear understanding of the collaborative process, how we work and what we do, and those issues that are so relevant to this being a different process. And so I think it starts with that at the onset, what I tell my clients is that this is a transparent process. And if you want to keep something confidential, I have to fall back, like you, Ken, or all the attorneys and others on the call. I have to fall back on my professional ethical guidelines. So I can't breach your confidentiality. However, I may not be able to work on your matter because it's not conducive to the collaborative process. And I would withdraw without breaching confidentiality, or I would encourage them to talk with either the mental health professional or whoever about how to share that information. So I worked on a case when I first got here, and I was called in kind of like an emergency room doc, which I know many of us know about, because the husband had disclosed to his lawyer that while still married, his girlfriend was pregnant, and not only that, but she was imminently moving um, to New York and going to bring her teenage son, and they were going to live together. But don't tell my wife.
House, yeah.
And so there were two young girls that were his biological girls. The other person had his girlfriend had a 13-year-old or 15-year-old son that had some mental health challenges, and she was pregnant. And so the lawyer felt much like what you're saying, that she didn't know if she could disclose this. And, I spoke about it as I'm speaking about it now, and spoke to him about it, that this is definitely going to impact his children. It's going to impact the outcome of the case. It's very relevant to the case, and that how could we engage in a collaborative process with these secrets? So it was either we had to withdraw or we had to share it. And we found a very methodical way to talk about it, to counsel him, to work on helping them have a conversation, and we were able to move forward. I just don't see how you could not do that and adhere to the collaborative principles. And again, this is such a different process, and it's different for a reason.
Yeah,
And
I'm going to just jump in here for a second, Randy, because it's a very compelling story. And what I want to highlight in particular that we can, I think, maybe all chew on across cases is there's the do you or don't you disclose, which is kind of a binary. But then there's another piece that you're just bringing us into with the highlights, which is how. Because most of our clients, they don't know how we could possibly do this without
Right.
the world blowing up.
right.
I mean, I always say that by right, no one should be able to logically go through a divorce process because everyone is probably emotionally flooded unless they've been separated for 10 years and they're finally getting around to doing paperwork. But you're emotionally flooded. Everything can feel very urgent, right? It's like, I think a metaphor I read somewhere, it's like tossing a compass to someone who's thrashing around in a storm, like it doesn't even seem possible. So we have to be that calmer, wiser other who can say, I know it might seem impossible to share this right now.
Right. And
it could also be really consequential not to share it right now.
Exactly. That's what I was going to say. I felt like it was a terrible breach to the wife.
Right.
I'm a neutral. And I felt like it would be a terrible breach to the wife for me to hold on to this information. So if he said you can't share it, I can't share it. I'm not looking for a lawsuit, and I'm not looking to breach my ethics. However, I couldn't work ethically on the matter if he wouldn't allow it.
Right. So let's bring in some, thank you for that example. I think there were some other hands and maybe.
Well, and you know what, Alana,
that
I
all
just wanted
right?
to make I just wanted to make a quick point. Alana and I had discussed the differences between lawyers and neutrals in the case. And so, I don't know how all of you do this work and maintain neutrality. For me, that's one of the most difficult things whenever I've been put in that position of maintaining neutrality. So you've got that added issue of not pissing off one person or the other by appearing to be taking sides.
Or betraying, I'll use that word, or betraying their trust.
Yeah,
And
yeah.
I would say that I think neutrality may at the end not be our best word. About 40 years ago, a family therapist in Milan wrote a paper about revisiting neutrality as multi-partiality, where you really give the feeling that each client can feel like you're thoroughly getting them, really embracing what they're going through, making sense of it. You're deeply connected to both, as opposed to okay, I'll be Switzerland, and I won't get too close to you and I won't get too close to you, because I don't think that does in the end really work. I'm sorry, though, I cut you off, Ken. You were gonna.
No, no, no. I mean, I just wanted to make the point that, being in that position of a neutral, and the difference between representing one of the clients in the process. I would also make the point that when I was handling this case, it was probably 2006, roughly, and we were not working with mental health professionals consistently, and how nice it would have been
Yeah.
to have a team, because I couldn't go to the other attorney and say, well, I don't want to divulge this confidentiality to everyone, but my client's girlfriend is pregnant. Um, so there was really no one else to talk to.
Right.
And so it really is wonderful that, in many cases, we do have the two of you and others, a team to have the conversation with. So I saw Ellen and I saw Melissa with hands up moments ago. Ellen, do you want to
I'm just going to
address?
reiterate that for me, it's a clear line. I can't breach my confidentiality, but I think one of the things I did like when we had two coaches, the two coach model allowed us to go to our coach on our kind of our team, our side of the team, and talk it through and see if we can, get the client to a place where they would be okay sharing something. But for me as an attorney, I it's very clear to me that I can't breach my confidentiality without consent, without my client saying, sure.
So you're saying you still kind of, even with the collaborative participation agreement for you, and I'm taking temperature checks here because, like I say, this was fascinating to me, when I had this experience a few months ago. So you're saying, yes, there's a participation agreement, but the thing that really grounds me and guides me is the attorney-client privilege.
Yes, and very often, and I'll say to my client, I think we should share this at the table. I think we should share this. And I tell them why, but I can't be the one to decide that.
Got you. So that's
Yeah.
interesting, right? I'm not as shocked as I was a few months ago, and that's how we got here, but interesting to know. Thank you for
And
sharing
Ellen, do
that.
you have a specific situation that's come up in a case, or?
No, but I could think of something that, somebody tells you they just got diagnosed with a very serious disease, and I don't want to share it with my spouse that I'm about to be divorced from. But it does impact parenting. It impacts everything, so it's something to talk about.
I'll pay you spousal support for 15 years, but I won't be here after 3.
You
Oh,
know,
well,
it impacts a lot. That's right. That's right. That's right. So that's an example, I think.
that's hard, right?
Thank you. Melissa?
Yeah, so I've withdrawn as a counsel when I've been asked to kind of hold information that's been relevant. And it's also a violation of the participation agreement too, in that way. And I went through it, it was information. It was with a client who had disclosed that he's having an affair, doesn't want any of the credit cards looked at, and she's not going to know about it. It's not, it was just a little bit more spending, but it was actually, I thought, pretty much more significant, and thought that it would be relevant. And and he was just adamant, like, I don't want this at all entered into it. And there were also implications, because I think there was also, he introduced her to the kids as his friend. It was just getting so, it was just so complicated. And he was like, you can't disclose this at all. He was telling me this. And so then I said, well, that's fine. I'm not going to disclose it, but I have to withdraw. And that's what we did. And I felt really good about it, because it was just a lot to hold. And I would feel it at that case, it was just one neutral that we were working with, but it just was such the antithesis of what the process is. I mean, this wasn't the process for him. He wanted me to be an attorney for him that was just not a collaborative attorney.
Right.
And how did you struggle with that? I mean, was that something that
I went right. It was actually a little bit simpler for me, because I looked at the participation agreement. He was asking me to do something that I really felt was just contrary to our whole process, and it was really relevant information. And quite frankly, he was also a really difficult client. So it was easy for me to just say, okay, I'm out. And it was oh my God, was that, it just was such a lift when you deal, because those client, I mean, he was just asking me to hold, it was just kind of, it was just, he was asking me to do things beyond. And then plus also the way that he was approaching, I think the collaborative wasn't, it was just, it was a relief. So I was thankful to leave,
To exit.
to
Yeah.
exit.
I
And then it
also,
also happened another time too, and another time where I was also told about, I don't know, what was the information? It was actually about how the client, she felt abused. It was like she was saying all these things about, feeling financially abused, all these abusive things. And I was like, well, maybe this process isn't for you. And she's like, well, I still want to do it. And she was saying all these things that I just did not think the process was appropriate because of the financial abuse that she was saying. And so I withdrew. She actually continued with another collaborative attorney. And I know what happened with that. It was just like a nightmare of a case. So I am so glad that I got through it, because there were a lot of issues. There were a lot of red flags.
yeah, no, it happens. And, Melissa and I had a case early on, probably my first collaborative case with Melissa in the mid 2000s. And it was a little bit different. Melissa's client had certain emotional issues, and I recall at one of our conferences about we were about to end the conference, and the client said to all of us that she was going to kill herself.
Oh my God.
And we ended up, again, we did not have a mental health professional in the case at that time. We ended up having the parties consult with a mental health professional, and we spoke to her. And it was a challenging situation. And she was Melissa's client. So I can only imagine what Melissa was dealing with in terms of conversations with this woman when the husband and I were not present. But that was a very uncomfortable situation.
Ugh, yeah,
God.
I remember that. Ugh. But
I'm almost,
we did work with we did work with the mental health. This was before, I think, even before the full interdisciplinary team
wow.
transitioned
Yeah,
to it. But we
yeah,
did get somebody right after the training. I think we got the training around that time. And then we bought somebody in, I think Joan.
Joan. Yeah,
Yeah.
It almost makes me wish that there were like, like if somebody wants to do collaborative as clients, that we could have like a sort of like a short, maybe no more than 40-minute like video that they could watch of actors sort of portraying different clients and how they felt like they had initially, like they had to just protect their side, and different examples of how thinking of the complexity of the whole together actually benefited them. Because really, we're asking people, it's really like the first time you go into a swimming pool and somebody says, I promise you're not going to drown.
Mm,
Like you
Mm.
see people in the water, they tell you it's going to be okay, but you really don't know it's going to be okay until you get into that pool and your head comes back up, right? And I think that's what this process might feel like to some of our clients. You're telling me I can collaborate. You're telling me it'll have a better outcome. You're telling me it might even save money. Everything in my body says we have rejected us as a collective, and we have to look, I have to look out for myself against the other person's
mm,
needs, right? It's very hard leap to make, and I think this is a piece of that.
yeah.
definitely.
Let me
And
just
if
let me
people,
second code. Teams. Collaborative teams.
so I just wanted to go back to the rules for a moment, and I'll do this quickly, but in the comment to Rule 1.6 on confidentiality, one of the comments talks about authorized disclosure. And it says, except to the extent that the client's instructions or special circumstances limit that authority, a lawyer may make disclosures of confidential information that are impliedly authorized by a client if the disclosures advance the best interests of the client and are either reasonable under the circumstances or customary in the professional community. In some situations, for example, a lawyer may be impliedly authorized to admit a fact that cannot properly be disputed or to make a disclosure that facilitates a satisfactory conclusion to a matter. So, it's interesting with collaborative. One could argue that this comment specifically addresses the collaborative situation and does provide us greater leeway. So I just wanted to, make sure that people were aware of that. Um, I don't think it fully answers the question because when we find ourselves in one of these situations where the client does say, like in Melissa's case and in my case, they don't want us to disclose the information, it really does tie one's hands to some extent.
Mhm. Definitely. Anybody
So,
else who hasn't spoken yet, like who maybe has had, I mean, I'm thinking about you, Ivy, I don't know if there are other financial professionals on the call. I certainly recognize you. Yes, and Gail also. Right. My fantasy is this is easier in certain ways for the two of you, and that it would be such a red flag if somebody said, here's some financial information, but don't tell. Is that fair to say?
Yeah, it certainly has happened. Um, and I do spend time like the other neutrals, like trying to make them realize that they need for it to be part of the process. But the good news is then I can always go back to the attorney that's representing the client that has divulged some information. So at least I have like a partner in that. And it goes back to teamwork. Like we function better as a team. So it's good that we would play off of each other. Um,
well, I think that's a really good point, Ivy, in terms of, um, is there, what would the process be going back to what Alana said initially? You have the binary yes, no, I can do it, I can't do it. But when this kind of issue comes up in a case, what makes sense for us? What how do we approach it? Is the attorney stuck in their own head? Do they have to think about it and deal with it on their own? Um, and from an attorney's perspective, and Myra, I would appreciate your input. From an attorney's perspective, do we violate the confidentiality rule by going to one of the other professionals and saying, here's what I'm struggling with? Do we even have the freedom in certain situations to have that conversation with other professionals in the room?
well, can't we have the conversation without I mean, because we all have, as a financial professional, I have confidentiality issues also. And I think that you can go back to the team. Sorry, Myra, then I'll let you go. I think you can go back to the team and say, look, I have a secret. My client has a secret. Help me. Again, isn't that one of the beauties of working in this process, that we do have each other, and hopefully you're working on cases with people that you feel comfortable with, they've had similar training. You may not have worked with them before, but at least if we've all had similar training, we're all more like-minded and we're participating in this process because of that. So
Yeah, no, I understand.
You
Myra?
know, it comes up in both collaborative and non-collaborative cases. And I think what my first act, if I had a real concern, is to take it to a respected colleague not within the group. So I'm not violating confidentiality. When I talk to another professional of any kind, whether it's financial or, this has come up in my collaborative case or whatever, what do you think? I'm not actually giving names or information, but we can always go to, non-party colleagues to ask questions. And I think those of us, sometimes I think the more we practice, the more our cases are more complicated, the more we do turn to respected colleagues for kind of input. But I think at the end of the day, as everybody said, at some point, you can't hold that secret, because it does taint the process, if not now, tomorrow. And if not tomorrow, at some other point when it's, going to be relevant. So we may hold a secret for a short period of time, like I think Ellen said about, a diagnosis. A client tells you, listen, my doctor's concerned, I'm going for a test. I don't want the other side to know. Well, it's fair till they know the results, because it may not be relevant and it's not worth, bringing it up. But once they have that information that is going to impact the case, and the same thing about a financial secret, I think, in litigation too, we can't, fail to disclose relevant financial information. So I think we have to do that. And our licenses and reputations are not worth, doing that. And we just have to tell, the client that I'm not going to do this. It's dishonest to the court, or it's dishonest to the process, and no good will come out of this because you'll get burnt by it in some way or another. But, we have to trust our instincts and our feelings about the process and how we want to participate. And I think that's more important also than any client. Nobody should make you do something you're not comfortable with, or think is unethical, improper. And, I think we should always stand by our instincts on that.
Yeah, I have some thoughts about the how, but let me, Gail, you've been wanting to say something. I wanted to bring your voice in.
You mentioned the idea of a video, and I think that's a great idea, because the analogy of the swimming pool, no matter how much we try to explain to clients what the process is about, I think having a video and making them watch it somehow is a great idea. It will further help them understand how this is
What
different.
this is and
Yeah.
why it could benefit. Thank you. I want to say that, from my mental health side of work, that when somebody brings up something that seems really problematic or noxious, I do first try to figure out why that might seem like a good idea to them. Like, I think if I want them to hear me, I have to show first that I can hear them. So maybe it would sound something like, I get that you are working really hard to figure out how to have this separate life now, And if they're the initiator, I might say, so you've been feeling this for a long time. Or if they're not the initiator, I might say, you're really trying to put one foot in front of another as fast as you can to sort of get a picture of what this new reality is. And it might seem like this is the most tender of information. Why would you turn to the very person that you're in the process of leaving, right? So I would try to find some way to align myself with, I get why this feels private. I get why this might feel like a really awkward time to share something that feels especially sensitive. And then I would say, and at the same time, given that your kids are going to be responding to this, or given that this could have real implications, you might really need to step away from work, it sounds like, for some period of time. Or you're telling me that right now, of course, sometimes things change. You don't expect to be here on this planet, in this earth, 3 years from now. And your would-be former spouse thinks you're signing an agreement with 10 years of spousal support. So let's just think about that for a second together. So I would try to first join them in why they want the privacy. And and then, because I think if they feel heard and understood, it gives it a little bit more chance that they create some space to hear the other, you know. So,
That's
Yeah,
why that's why you're in the room. You see, no, I'm serious. I mean, I know my lane, right? I mean,
yeah, yeah,
that's a beautiful way of dealing with it, but am I going to be qualified to say it that way? I hear you. I would hope that I could if you know, but
yeah,
that's why I would want to go to a mental health professional and have someone talk to my client about,
yeah,
about that way and that gentle way.
yeah.
Not that
Thank
I'm
you.
not gentle and kind, but
Right, right, right. It took me a while to get this. So,
so
yeah.
that's
And I'm just giving you like one option that we might have in our toolbox to just sort of help somebody feel heard and understood, and then be able to come back to the question of what's
mm,
shared, what's not shared, you know. The
yeah, and
very person that rejected me, I'm going to tell them the most sensitive information. I haven't even told my family yet about this diagnosis. You know, my parents and my sister don't know. And now I've got to turn and tell them when they don't even want the best me under the best of
they'll
circumstances.
probably
I mean that
celebrate. They'll say they'll celebrate.
that yeah, I mean that you can understand why that would be hard, right?
Yes, it's very hard.
Yeah. Somebody had a hand. Oh.
Oh, well,
yeah, and I see Melissa, but I also, after Melissa talks, I'd appreciate if Andrea and um, Michelle, if you had
no, I
anything
don't
to
need to.
weigh in on, I'd
Yeah.
appreciate that.
I yield my time. I don't need to.
No, no, you start so they can think.
All right. No, I just was what Myra was saying. I actually have like a list when I am struggling, and Ken, you're on the list. I think Ellen's on like maybe everyone here. I don't know, but I call up people. And earlier, like I always had my gold standard, which was like Mary Ellen Linehan and Peg Clark, because they're like so process oriented, so ethical. And I would always, even in that case, I'm remembering with that case, I think the first person I called was Mary Ellen, and she's like, Melissa, go back to the participation agreement. Like she like set me straight, because you get so like, oh my God, what am I going to do? And getting
Yeah.
that perspective was so clarifying. And that's what I do when I'm struggling and I can't necessarily speak to the team or how to approach the team. Getting outside help, and we have so many amazing people in our organization. That's like the biggest benefit of being a member of this association is we just have such amazing colleagues that you can just bounce off ideas on how to approach it when you're really struggling. But I do think listening to your gut and just like when you know something is wrong, just kind of listen to it, because when you go against it, it's like, I don't know, for me, it's just listening to it intuitively when you do enough number of cases. But when something doesn't seem right, and yeah, it's a good resource. So that's all I
Thank you,
have to
Melissa.
say.
Yep. Michelle, I see you
If
were
you want.
kind enough to
Except
I'm
unmute yourself.
volunteering, sort of. Hi, everybody. Well, I really appreciate and agree with, everything that everyone's saying. So I'm just gonna layer on a little bit, the way that I handle these situations. I have a little bit of a test, which is if the other side had this information, would it change anything? Would it impact the agreement? So for example, and this is a not a real thing that happened, but if a client confided in me that they had had an affair at the beginning of the marriage 20 years ago, that might be devastating to the other spouse, but probably is completely irrelevant for the way that they structure their divorce, their finances, their visitation, etc. So that would be something that I would be comfortable withholding if I were asked to keep it a secret, even though it's obviously important and you would hope someday it would be maybe revealed, but I wouldn't, if a client divulges something that is going to impact whether it's the parenting agreement or the finances, then I don't really give them a choice, right? It's, you signed an agreement um, to engage in full and fair and honest disclosure. And, that's what this process is. And usually I can get people to cooperate. I've never had to withdraw from a matter because I couldn't get a client to cooperate where the issue was relevant to the settlement. But if I can see a way where it's not relevant, even though it's very hard for me to sit with it because I want to tell someone or I want to speak to my colleagues about it, or it's just so interesting, I can hold back and not tell anyone as long as I can convince myself that it's ethically not impacting
Yeah.
in any way, shape, or form the settlement that they're going to reach.
And I, by the way, had that case as on the therapy side. A woman had an affair while she was engaged. Actually, she slept with somebody once, 22 years before, had never forgiven herself ever, you know. So yes, but would not have been relevant to a settlement, I think. There was one other person who hadn't spoken yet, I
Andrew.
think.
Well, I mentioned Andrea. I see Mary Kelly, and I know Rachel's also, but they're not on the video. But Andrea, do you have anything you'd like to weigh in on?
I don't have anything to add. I appreciate everything that's been said. I like some of the language that Alana's been offering about how to approach the client. But I mean, I agree with what's been said. I like what Michelle said, that it's different than mediation, where, in mediation, I don't like to keep any secrets whatsoever, because how do I know if it's going to impact it or not? But when it's your client and it's a little different, like you can do that test that Michelle was suggesting. So yeah, I just like everything that's being said. Thank you.
Myra, do you want to add something?
I think also we have to remember, there's often a whole anonymous chorus of people that the participants are also talking to outside the group. Their best friend, their brother-in-law who knows a lawyer who knows a lawyer. There's all that sort of background chorus. And sometimes also, I think we have to remember, why people may say things that we find distasteful or are concerned about is because that's what the chorus is telling them. You'd be crazy to tell your spouse X. And I think we also, our role is to sort of clear it out. As you say, Alana, why is this? Why are you withholding it? And sometimes it's also pressure from people who are not part of the process. And people don't want to feel stupid in their, group. And so sometimes we're almost giving them permission that they really want to be the better participant and to ignore that whole chorus of everybody who's telling them what to do. Because I find sometimes that background chorus is a very heavy thing to deal with, when you're trying to manage your case. So that's food for thought too. Whether it's a relative or a buddy at work or somebody.
Right.
They're getting so many voices on what they should do.
Everyone wants to weigh in on someone else's divorce, right?
Friends and relatives law. That's what I call it.
Yeah.
I
Well,
just wanted to ask,
yeah.
oh, sorry. I just wanted to ask Ken if there was any fallout from the case you started with the pregnant person.
Never heard any fallout. My client, to some degree, got himself into a difficult
Pickle.
situation because it was a situation where the party's child was very, very young. I mean, I think maybe 3 years old, 4 years old. Um, and but my client got himself into a pickle financially because he was making commitments in the divorce, in the collaborative, to child support, future obligations. And, it was clear that he was the one who wanted the divorce. It was one of those situations where one party made the decision, and in that case, the wife, throughout the collaborative process, was struggling with the decision. And so, years later, hearing from him and hearing that he had all of these expenses with his new family, and how could he, continue to meet his child support obligation or his other obligation. So I think that would probably, those are the ramifications more than anything on the wife's side. So,
Yeah.
but thank you.
Interesting.
I appreciate it. Good question.
I
So,
like the
I-
standard of how would you feel if the other side had this secret information, if
yeah,
you're trying to decide if the case can go forward. So,
Right.
and if he had weathered the news sharing, would he have been able to be more balanced in his projections about what he could do?
right.
I just want to say this has been so interesting to hear all your experiences. Like, I'm glad that we could co-host this conversation. I don't know if it means, if does it lead to anything different in our participation agreement, what we say to people. I'll just leave that as a big question mark, because in the space of an hour, we can just raise a lot of question marks, I think. I don't know. Ken, what are your thoughts as we get ready to wind up?
Well, I mean, I think it's an interesting and important conversation for the attorneys in the room. I would encourage you to take a look at the rules of conduct that the New York State Bar Association has on its website, and I found them very easily by just Googling. And so you don't have to print out the 275 pages that I have sitting on my lap. Um, and no, I appreciate having the conversation. And I would just acknowledge that I think this originated from a discussion between Melissa and Alana and, about the situation that Alana described initially. And, another aspect of it for me is, there are many people in the organization as attorneys who do only collaborative and mediation. And there are some of us who do litigation as well. And I think, for those of us who do litigation, we work very hard not to allow the litigation component of our lives to color the collaborative component, because in litigation, it's more of a black and white, you know, because you're not going to disclose something like that to the other side. And so, I think that's another part to be aware of. And it's something that I'm aware of. It's funny, the earliest trainings that I remember doing at the Lincoln Building back in 2005, whatever. And I remember these other attorneys who were clearly litigators who never really got involved with collaborative. But I remember overhearing one of them saying something that I thought was very pompous, and that I know within 15 minutes of meeting with a client how that case is going to settle.
It had to be
Uh,
Henry Berman.
who?
Henry Berman.
Oh gosh, no, it wasn't Henry, but it could have been.
Okay.
So it's a different mindset. But for those of us um, who are able to do the collaborative and also do litigation, there is a little bit of a difference, but I think we work very hard at it to make sure we're being as collaborative and transparent as possible.
But I think that's also one of the hallmarks of what makes collaborative different. I mean, if in the collaborative process we find a mistake that the other side made, we have to bring it to their attention. And in litigation, you just go and kick your heels up and have a drink.
Not
What
all,
idiots! They made a mistake.
not all of us.
Well, and there's also protocols too that I think just to look at, and it's, time to review it and to update
Yeah.
it. That NYCP has that kind of deals a lot with these issues. And it's a good, if anyone wants to kind of work, I think that's a committee that we need to kind of get going, but that if anyone has an interest in it, it's something to relook at because we do have protocols on our website. And I think it deals with some of these issues that we're speaking about.
And Melissa, I think this is a good time to plug because I think we can raise this. We're doing an interdisciplinary training
That's
on
right.
May 15 and 16. And I think in that training, we can I'm going to take it as a refresher because it's not just for newbies, it's also for people who want to refresh because I haven't taken the training in a long, long time. And I think it's a topic to raise, see how the trainers,
Nice.
what do you have to say about it? Because I
Yeah.
think it's an important topic and thank you for doing it. I just want to remind everyone to fill out your evaluation if you want your CE credit. You're going to get it later in the day today from Sarah. So I hope
Perfect.
everybody.
Well,
weekend.
thank
Thanks,
you.
everybody, for your
Thank you.
participation.
Oh, thank you for doing this. This was
Great
good.
topic. That was really, we'll all be thinking about it as we
Yeah.
leave the room.
Right.
Yeah.
Yeah.
For sure.
Thank you. And it
Alrighty.
was an honor to present with Alana, who
Oh,
presents
no, I
all
was
the
very
time, all
glad.
over the world.
Yeah, please. All right. Bye.
Thank
Was
you.
glad
Bye.
Thank you. Have a good weekend, all.
Thank you, Ken.
Take care.
Bye-bye.